Hello, so in this video I'm going to be talking a bit about the Mental Capacity Act, but specifically focusing on practitioners doing these assessments. So some things that I've picked up from being a social worker completing the assessments and also a best interest assessor. In terms of the most important thing, it's about making sure that you're following the 5 statutory principles of the MCA. So I remember these by the acronym Paul B that I was told about, and I think it's helpful. So P stands for presumption of capacity, A stands for all practicable steps, U stands for people have the right to make unwise decisions, and L stands for least restrictive principle, and B stands for best interests. So we always have to make sure we're applying these in our assessments and also in our general practice as well. So just because we may not be having to utilise the Mental Capacity Act, it doesn't mean that we don't consider that piece of legislation. So I think sometimes people get mixed up because when you're sort of, one of the principles being assume capacity, they think that we can't sort of include that if we're saying that someone has capacity, but actually in case notes, sometimes if you're considering a safeguarding issue or just a general conversation, you can say the person appeared lucid at the time of the discussion and actually you had no doubts around their capacity relating to a specific decision, and detail that just so that you're sort of considering it but you're not actually utilising it, and that's fine. But then in terms of when you have got reason to think that someone's not able to make a decision, then this is where you're going to be using the Mental Capacity Act and doing a formal assessment. So the formality of the assessments really depends on the significance of the decision to be made. So bigger decisions require more formal assessments, but more day-to-day decisions that are not having a significant impact require less formal. The burden of sort of justifying and proving that you've got evidence to suggest that someone lacks capacity based on a balance of probability, it being more likely than not that someone lacks capacity, is important to consider, because you need to make sure that you are proving that, and the person that's required to prove that someone doesn't have capacity is the person that's actually completing the assessment. The person being assessed doesn't have to prove anything to you. So in terms of the Act itself, it is human rights based at its core because it's about protecting people's rights in general. So people having the right to have decisions made for them when they're unable. That's something I read in Matt Graham's book, and I found that really helpful because sometimes you feel bad like using the Capacity Act because you just want people to be able to make their own decisions, but actually some people really cannot make their own decisions because of an impairment or disturbance, so it's the right thing for decisions to be made for them. But that's where it's so important to actually use those and apply the principles, because then you're going to be doing it in a way that makes sure that you're looking at all the relevant information, people's past wishes, you're not discriminating against people based on their appearance or their cognition diagnosis. You know, you're not sort of making assumptions based on anything. It has to be balanced. You have to prove that you're making decisions in someone's best interests and document that clearly. So it is protecting people in that way, and it also provides people with the opportunity to make decisions before they may lose capacity. So often people may make advanced decisions, so decisions about medical treatment, for example, in advance while they have the ability to do so, or they may get a lasting power of attorney over health or finance, so that's something that it allows for. But then in terms of the actual assessment, it's decision and time specific. So decision specific as in, just because someone can make a decision about, say, what food they want to have doesn't mean that they would be able to have capacity around their finances or more complex matters. That's just 2 examples, but each of those things and different decisions require a separate assessment. It's time specific because just because someone's been assessed as not having capacity about something at one point in time doesn't mean that that can't change in the future. People's sort of cognition or ability to make decisions can change, and sometimes people may lack capacity because of something that's temporary, like if they're under the influence of alcohol or something, they may not be able to make a decision, but then that goes away and they can again, or someone may be unconscious. But also people may have longer term conditions that are unlikely to change. So that might be someone with a learning disability or dementia. But you can't judge it on those basis. It's really about taking the person as they are and assessing them properly and applying those principles I mentioned. So in terms of sort of your approach to the assessment, there is a 2-stage test. So the first stage is the functional test, and that's about whether a person is unable to make a particular decision based on their inability to understand, retain, weigh up and communicate a decision. Stage 2 is the diagnostic test. So that's where it relates to a person being unable to make a decision because of a disturbance or impairment of the mind or brain, the way it's functioning. So this is where it could be a long-term disturbance or a temporary one. Every effort should be made to communicate with someone in a way that they understand, and people have the right to have an IMCA, so an independent mental capacity advocate, if they don't have anyone to represent or support them. If someone has particular difficulty with communicating, you can get a speech and language therapist, and you have to consider that. You also need to consider other ways of getting the information across to someone if you feel that they don't understand verbal communication. So that might be writing on a whiteboard if they prefer to look at it that way, or pictures. And really it is important that you evidence that you tried different things, because we're required to take all practicable steps to help people to make their own decisions. We also need to evidence that we've given people the opportunity to make their own decisions in other ways. So thinking about the time of the day that people may be best able to make a decision, or speaking to family members about their communication preferences, or thinking about whether they'd like to have someone there that would make them feel more comfortable, so then they can engage better in the assessment. I would also say that I do think that you could do an initial assessment and then a further assessment, and maybe even more than that. And during the initial assessment you may ask a few questions, but then go back, reflect and think about what you need to really zone in on, and areas where you feel that a person may be struggling with something that's relevant to that assessment. Relevant factors are things that are relevant to the decision to be made. So you need to be very clear on the exact decision to be made. Write that down ahead so that you know what it is, and then you need to be writing down what you think is relevant to that decision. I find that Essex Chambers have a really good guidance note around this, and they break down different decisions and relevant factors relating to that, so I'll put a link to that in the description. And in general I just find that the stuff on Essex Chambers is really helpful, and you can keep up to date with case law from looking at their website and getting their sort of emails as well. So I hope that's been helpful.